Mr. Monks.
Lady, thank you. Before I continue with my submissions, may I come back to a couple of points? The first is to come back very briefly to my Lord Sumption's point as to the priority enjoyed in insolvency. One starts with the position that a statutory charging order does enjoy priority. A common law lien, strictly so-called, enjoys priority. And on the equitable lien, there are two conflicting cases. This, my lords, is not one where we have to resolve the conflict. But they're both in the bundle. If I can just mention that in re Meter Cabs Limited in 1911, which is at the bundle at A2 at tab 24, in the Chancery Division, Mr. Justice Swinfen Eadie held that what was essentially an equitable lien, though he describes it as a common law lien, prevailed. Whereas in the Jones and Bibby case in 1949, which is at tab 14 in Authorities Bundle 1, Lord Goddard held in the Divisional Court that a claimant should apply for a charging order, because if he did not apply for a charging order, he would otherwise only have an incoherent right to apply for a charging order, and the equitable lien would not take priority. But, my lady, I don't submit that in fact, is crucial in answering any of the questions that arise in this case. The second point is this, and it's really by way of background to explain how the CFA Light gained regulatory force. And if I may just read you, because it's not in the bundle at all, the provision of CPR 44.1.3, which is providing for recovery in spite of the fact that it's a CFA Light only. And it provides as follows: where advocacy or litigation services are provided to a client under a CFA, costs are recoverable under parts 44 to 47, notwithstanding that the client is liable to pay the legal representative's fees and expenses only to the extent that sums are recovered in respect of the proceedings, whether by way of costs or otherwise. And what we say about that is it explains this point about responsibility or liability in the client care letter, and comes back to explaining the point that we were discussing earlier, that the client is only going to be liable for any costs, but nevertheless the costs that he would otherwise have been liable for are only recoverable. And it's an answer to the indemnity principle, as my learned friend, Mr. Carpenter, explained. It may be also helpful if I refer to you, without inviting you to read it now, to two paragraphs in the judgment of Lord Justice Waller in the Jones and Wrexham case, to which I've already referred, at MS 191 to 192, paragraphs 10 and 11 give a background to the regulatory history of the CFA Lights, which is helpful. Coming back...
Lord Marks, would you mind my just asking this? I've been, over the short adjournment, fretting slightly over a point that I thought you were making about quantum. Namely, why should the damages, 12,423, based upon stage 1 and stage 2 under the protocol, be payable? So that was really a quantum point. But then I realized it's not an issue before us. It's not one of the issues, is it?
It's not strictly one of the issues that arises in this appeal. I prayed it in aid as being the point that what was claimed in these proceedings and awarded in these proceedings was effectively damages in respect of the amounts that might have been recoverable as fixed costs had the case settled under the protocol, as distinct from and in excess of any amount that might have been recovered under a lien. Because a lien would only arise in respect of costs that were payable by the client. And that lien would be limited both by the amount of those costs, but also by the fund available. The fund available, and this was the point I was making at that stage, was the amount of the settlements. The amount of the settlements were less than the amount of the costs in respect of which the claimants claimed damages and were awarded damages. And my point is that that simply doesn't make sense. And I pray at an aid in answer to, or in support of our submission, that only a lien will do. A lien can only arise in respect of a right to costs against the client. And I also pray at an aid in respect of the submission that I'm now making, that there is no entitlement under the protocol in Edmondson to recover the costs.
Very well. You were making the point in terms of one of your liability submissions. You're not making a discrete point about quantum.
The amount involved, as my lady pointed out, is
very well
small. I might have that point available, but since we'd be talking about
Thank you.
£100, that would be not sensible. The final point I wanted to come back to is really bringing me back to my submissions on 737, which is that I hope my Lord Briggs and I were not at cross purposes when we discussed the meaning of the words "at any stage." I am not saying that at any stage doesn't mean at any stage of the protocol. I accept it means at any stage of the protocol, but I say that's subject to the proviso that it is an offer made within the protocol at any stage of the protocol. And my primary point here is that this is not an offer made within the protocol, it's an offer made entirely without the protocol.
So where one looks at 737, you say one doesn't look at it as a sort of protocol instruction, but perhaps only as a way of identifying whether it's made within the protocol at all. It says, and cannot exclude.
I wouldn't limit it quite in that way, but yes. If it is not, if an offer deliberately does not comply, and remember this is a non-mandatory protocol, if an offer does not comply with 737, then it is not a protocol offer. And I'll come back to that in just a moment, if I may, because just to complete what I was saying before the short adjournment. I do rely on the fact that 740 provides that the obligation to pay the agreed damages, the unpaid stage 1 costs and the stage 2 costs, that only arises within 10 days of the end of the relevant period in paragraph 728 and 730. And you see that halfway down the page under 5. Now, paragraph 728 and 730 refer specifically to offers made and counter-offers made during what they call the consideration period. And there is only a consideration period if the protocol procedure is followed. And we simply say, in this case, the settlements were agreed without any CNF response form, let alone without a consideration period. And we say that supports the proposition that these offers were entirely outside the protocol. And coming back to my Lord Briggs's question, we say that the fact that an express agreement would not include the costs reached otherwise than in accordance with the protocol, because the protocol is not mandatory, the fact that that agreement is reached doesn't mean that it has to be interpreted as somehow deeming an agreement to pay costs. And we submit that that's an error. It's not expressed as such, but it is in fact a part of the logic gone through by the Court of Appeal in reaching the conclusion that there's an entitlement. Because the entitlement only arises if 737, which is a non-mandatory requirement properly construed, is treated as a deeming provision. And we say it's not just harsh, but in contradiction with ordinary principles of construction, to treat 737 as a deeming provision when it would be in direct conflict with what was actually agreed between the RTA claimants and Haven. And we say that also adds another reason for holding that 737 can only apply to offers made within the protocol. Because if it were treated as a deeming provision, then the court would be in what we say is an unattractive and unrealistic position of imposing on the parties to the settlement, they having agreed, knowing perfectly well that nothing was said about costs and that there'd be no extra payment, imposing on those parties a term directly contrary to what they'd agreed. And we go on to come back to the pleadings in this case. They never said in their pleadings, we are entitled under 737 to recover the stage 1 and stage 2 costs. What they said was you didn't comply with the protocol because you didn't make an offer in accordance with 737, and that has caused us, Edmondson, to suffer loss. That is completely different from saying that Edmondson had an entitlement to costs in those sums. So we say that their pleaded case effectively is only consistent with accepting that 737 does no more than impose a requirement on a party making an offer with which the party is at liberty, from which the party is at liberty to depart, and which happened in this case by agreement. And we say that given the Court of Appeal's agreement in paragraph 32, that it was open to Haven to enter into compromise agreements with the claimants outside the protocol, it's completely artificial, and we would submit wrong, to suggest that on so doing, somehow a liability to fixed costs under 737 was established. Now, it's perfectly true that sometimes contractual provisions are imposed on parties or invalidated by statute, even where they may contradict the terms of the parties' agreement. In the context of this case, one thinks of cooling off period. In the context of other statutes imposing implied terms, those terms can be contradictory, can contradict the parties' words. Say, if you're going to have a deeming provision that makes a contract different from what the parties agreed, it has to be very clear that that was the intention of the statute from its words. And that is not true of 737 of the protocol. We say that the application of 737 can be properly limited to offers within and in accordance with the protocol without in any sense doing violence to its language, and from the submissions that I've seen, made plainly in accordance.
But how do you tell whether an offer is within and in accordance with the protocol? Do you say it's only within it if it does include all these extra items? Or it's only in if it's made electronically? Or if it's only in it if it says this is an offer made pursuant to the protocol? If on the face of it, it appears to apply to any offers for settlement made at a time when the protocol is up and running.
Subject to de minimis exceptions, I suspect that's right.
Which? Sorry, I offered you about three alternatives.
First alternative, that it's only that it is an offer in accordance with the protocol if it includes or cannot exclude, or an offer made within the protocol when it's plainly made during the consideration period, and the offeror or the defendant says, my offer is £2,000 and it's within the protocol and it's in accordance with the settlement pack, then it could be said that takes effect in accordance with 737 and includes the extra payment of fixed costs. Because that's the way protocol offers are made. cannot be applicable where the parties expressly agree, as they did in this case, and that's common ground, that there will be no costs. We are settling this at £2,000, £2,300, £1,900, and there'll be no costs. And we say it is significant that in its written case, Edmondson doesn't contend that 737 directly imposes an obligation to pay stage 1 and stage 2 costs. It argues, and this is at paragraph 71 of its written case, page 1168, that what Edmondson did was effectively to undertake a contractual obligation by conduct, either to Edmondson direct, which is a 71.1, or at 71.2, direct to the RTA claimants. So my learned friends are saying this arises in contract. And the conduct relied on is first acknowledging the CNF in the first place, which goes back to the submission I made before the short adjournment, and secondly, refraining from taking any steps to remove the claim from the protocol. That's the first paragraph of 71. We say that argument is unsustainable. I've dealt with the lack of significance of the acknowledgement, but refraining from taking any steps to remove the claim from the protocol cannot be relevant conduct where no positive steps were required, and the failure to take any steps would, after 15 days, have led to the protocol being abandoned in any event, automatically. Furthermore, we say that there is an express contract, which is common ground, that there will be no cost consequences. And you can't set up a contract by conduct in opposition to a contract that is expressly agreed. I then come to the next point that we make, which is that there is no so-called normal course of events, as mentioned by the Court of Appeal, or suggested by the Court of Appeal. The rules don't demonstrate an entitlement, and as a matter of fact, on the evidence that you have, cases don't stay within the protocol. The ICF report exhibited to Mr. Marshall's witness statement says this: in a large proportion of cases, the value under £10,000 have historically fallen out of the RTA portal because either intermediaries do not seek deadlines or cases have complicating factors. Then at paragraph 16...
Do you have a page for that? Come back to it if you get assistance.
I'm so sorry. It's in the ICF. Can I take you, though, meanwhile, to page 1087, paragraph 16 of the Statement of Facts and Issues. In the first 3 years of the protocol, over 2.25 million claims were notified through the portal. Of these, over 600,000 settled at stage 2, with only 1.3% progressing to stage 3. Most cases were therefore either not pursued or were resolved outside of the protocol, either by settlement or Part 7 proceedings. And then there's further discussion of the statistics in the White Book. So that supports our submission that following the protocol by entering the portal gives claimant solicitors no more than a contingent expectation of securing an order for stage 1 or stage 2 costs, because they only get there if the protocol procedure is followed all the way through to settlement. Our next submission, if you've got that page. Page 937, I'm so sorry. That's the page in the ICF report. Gavin tells me it's the mark. Yes, this it's an page 937. I may have got the report wrong. Our next submission is that any entitlement belonged to the RTA claimant, not to Edmondson. We say that's the fourth flaw in Edmondson's analysis. An offer to pay the costs would have been an offer to pay those costs to the RTA claimants. Any entitlement belonged to them. It's quite clear from the terms of the protocol that offers flow between claimant and defendant as parties, there's no suggestion that an offer is paid to pay costs to the solicitors, even though, as we've established, the solicitors are going ultimately to get their fixed costs. My lady, our written case refers at paragraphs 61 and 62 to the case of Hollins and Russell, which is a Divider 12 in Authorities Bundle 1, MS 99, where Lord Justice Brooke confirmed, as really everyone knows, that a costs claim belongs to the client, not to the solicitor, notwithstanding that that case involves solicitors recovering costs where there were CFAs in place. My lady, that, we say, is a complete answer to the first route to entitlement mentioned in paragraph 31 of the Court of Appeal's judgment. There is no basis for arguing that Edmondson, as solicitors, somehow achieved a direct right themselves to costs against the insurers. Lady Edmondson attempts to deal with this at paragraph 72.1 of its written case by arguing that the court is dealing not with an inter partes costs order in ordinary civil litigation, but they say with a sui generis regime established for the purpose of avoiding court proceedings. So, says Edmondson, all depends on the terms of that regime. We agree that this is a regime designed to avoid court proceedings. But nowhere does Edmondson identify a provision in the protocol that transfers the right to recover fixed costs from the RTA claimants to the solicitors. There is no such provision, and indeed the protocol expressly contradicts it by talking about offers from a defendant to claimant. Even 737 refers to an offer to settle made at any stage by either party. The next point that we make is directed at the so-called second route to entitlement under the right to sue in the names of the clients. And we say that that simply cannot work. It is in effect a subrogated claim that the Court of Appeal was suggesting. But Edmondson can have no better claim by subrogation, and this is fundamental, than the RTA claimants, its clients, could have had themselves. And every defence available to Haven in any action brought by the RTA claimants would be available to Haven in an action brought on a subrogated basis by Edmondson. And they couldn't possibly, the RTA claimants couldn't possibly have an entitlement to sue Haven for costs because they had expressly agreed that there would be no costs. Edmondson answers this point by saying, the whole purpose and value of equity's ability to intervene arises in circumstances where the solicitor does not have an effective legal remedy because of what the paying party and his own client have done. But that isn't an answer to this point at all. It may be a relevant point in relation to collusion, but it's not a relevant point in relation to entitlement. And the argument that they put fudges the distinction between entitlement and the circumstances in which equity might afford such an entitlement protection. So we would say if there were such an entitlement in the solicitor, then the solicitor would seek intervention. He doesn't need a subrogated claim because he relies on his equitable lien. But if there is no such entitlement, suing in the name of the clients doesn't make it any better. And we say then that in order to succeed in establishing an entitlement, the solicitor would have to bring himself within the principle of Carnes, and that presupposes the right to recover and the lien, as a result, the right to recover over a fund. So we say that the conclusions are that of the submissions so far is that what the Court of Appeal was effectively doing was purporting to establish a new jurisdiction, first to grant a solicitor an equitable lien in the absence of a right to claim costs from the client, as discussed earlier. Secondly, in giving a non-mandatory pre-action protocol mandatory force, whether by giving it contractual effect, as Edmondson contend, or otherwise. Thirdly, giving a solicitor a right to claim costs against a defendant in his own name, when those costs are properly due to the solicitor's client, if at all. And we say, of course, they're not. And fourthly, in allowing a subrogated claim on behalf of a solicitor's client in circumstances where that client could not have succeeded in such a claim. Now, 3 and 4 there are, of course, expressed by the Court of Appeal as alternatives, but we would say, frankly, that they fall into the category of what might be cruelly called claimant swapping, against a background when the courts have been rigorous in ensuring that only a claimant with a legal entitlement can properly bring a claim. My lady, that brings me to my next principal submission, which is that if Edmondson had no legal entitlement to recover costs from its clients or sums under the protocol, it had no interest that equity could or should protect by equitable intervention. That is issue 3 in the Statement of Facts and Issues. And in a sense, it's a relatively short issue. Edmondson argues, this is paragraph 74 of its written case, that the Court of Appeal may have intended only to say that Edmondson had a sufficiently legitimate and well-founded expectation of receiving its costs under the protocol, that equity should be prepared to consider intervening in its protection, even if Edmondson had no legally enforceable right to costs. Edmondson goes on to argue at paragraph 75 that if such an argument was intended by the Court of Appeal, it would be unassailable. Its grounds being effectively that the policy of the protocol favours permitting equity to intervene to enable Edmondson to recover costs against Haven. However, we say that the interpretation inherent in that argument of the Court of Appeal's judgment is wrong, because it's clear from paragraph 31 at 1227 that the Court of Appeal regarded Edmondson's entitlement as a precondition to equitable intervention. So the judgment says, while Edmondson has no right to recover fees from its clients, I consider that in the normal course of events, Edmondson would have an entitlement to recover the fixed costs and other sums payable under the scheme. Then he goes on, either an entitlement in Edmondson itself. Edmondson's argument doesn't grapple with that. We submit no entitlement, as I've perhaps laboriously submitted this morning, but we go on from that to say that you cannot get home without an entitlement. And Edmondson cannot imply with justification that anything as tenuous as a sufficiently legitimate and well-founded expectation of receiving its costs under the protocol would be a proper substitute for entitlement. And we say all the authorities make it absolutely clear that entitlement is a precondition for equity's intervention. That brings me to our sixth submission, which is on notice. And we say that Haven did not have sufficient notice of a lien or of any other interest which would engage the court's equitable jurisdiction on the principle in Carnes. That's issue 4 in the statement of facts and issues. We submit that on the authorities what is required is express notice of an entitlement to establish the notice route in Cairns, and we rely on our written case in support of that submission, and again say no entitlement is no lien. On the facts of this case, however, we question whether the question of whether notice has to be express or implied is less important than first appeared. And that is because it's common ground, and we accept, that Edmondson itself completed and submitted the CNFs on behalf of the RTA claimants. And Edmondson does not argue that Haven was on notice of anything that was not contained in the CNFs. So the notice relies on the CNFs. I say that with the possible exception that Edmondson may be arguing that Haven ought to have deduced that the CFA was likely to be a CFA light. And the suggestion that they make doesn't go anywhere near saying they had notice of the fact that it was a CFA light, and of course they did not. And we concede that nothing turns on the fact, in terms of notice, that information was received by Haven directly from Mr. Tonkin before the CFA was served. But we rely on our written case at paragraphs 91 to 105 in support of the proposition that on the authorities notice has to be express. But what we say is important is the question, what is it that Haven, the paying party, has to have notice of in order to be liable to equitable intervention? And we accept that the CNF gave express notice, first, that Edmondson was instructed, secondly, that Edmondson was retained under a CFA, its nature being undefined. That is section L of the CNF, which for your note is at MS 1298. Thirdly, that the RTA claimants had issued CNFs under the protocol, with the effect being that Haven would either issue an insurance response admitting liability, subject only to seatbelt contrib, or the claim would leave the protocol. And fourthly, that if, but only if, Haven and the RTA claimants followed the protocol and the claim settled in accordance with the protocol, then the claimants would have a right to claim stage 1 and stage 2 costs against Haven under paragraph 740. And that's notice that follows from the terms of the protocol rather than the CNF itself, but we accept that Haven would have known that. However, Haven did not have notice of the following points. It had no notice of the terms of the CNFs. CFMs, I'm so sorry. I've been calling them CNFs. It did not have notice of any right in Edmondson to recover its fees from the RTA claimants. The nearest they get to it in terms of evidence is Mr. Marshall saying, upon seeing the notification in the CNF that the claimant was being represented on a CFA basis, Haven could have been expected to conclude that this, that is a CFA light, might well have been the formulation being used. That is not within a million miles of notice that this was a CFA light.
But all CFAs have to have some right of recovery or some responsibility on the part of the client, don't they? Even if only the light version, which you describe as being a purely theoretical one.
Purely theoretical until we get down to the track, to the point of recovery.
Yes, but
Yes.
what I'm asking you is the extent of the responsibility you put
Zero.
at the vestigial end of reality.
Yes.
But across the whole panoply of possible CFAs, it would either be that or something more than that, wouldn't it?
Oh, indeed it could. And under the more recent arrangements where solicitors reserve for themselves because now success fees aren't recoverable, reserve for themselves the right to take out of the damages some of the
Yes.
success fee. Of course, that's a right they reserve under that sort of CFA.
Yes.
My point, and the point we canvassed before the adjournment, is that with this CFA light, which was no recovery unless and until there is a right to recover fixed costs, there is no fund and no lien until that date.
I understand that. We're just on the question of notice here.
Yes.
It's difficult to think if you're notified that the solicitors, that the claimant has got solicitors acting under a
Yes.
CFA,
Yes.
then it's either going to be an ordinary CFA or a CFA light, as matters then stood, isn't it?
Yes.
If it's an ordinary CFA, they will undoubtedly have a responsibility to pay costs,
Yes.
sufficient to trigger a lien.
Yes.
If it's this kind of CFA, it will be the CFA light responsibility,
Yes.
which you say is not one that has any practical reality. Now, if you're right about that, then the notice point, I mean, on the face of it doesn't arise. But if you're wrong about that, they must have had notice of at least that degree of responsibility, mustn't they? Because if there wasn't even that, it wouldn't be a CFA.
They've got notice that there's a CFA.
Yes.
Yes.
So, I mean, it doesn't sound like a notice point.
Well, they're within my notice points, because what I'm saying, since I say that there is no active lien, no effective lien, until the date of, I do maintain the point. There is no lien until the point of recovery, because at that stage, until that stage, there is no fund.
Well, I think I understand
Yes,
what you say about what it means, but you're not, I think, saying that it meant something of which the Haven didn't even have notice, in the sense that actually it meant more than what they had notice of.
It has notice of an either-or, but it doesn't have notice that there
Yes.
is an
Yeah,
effective
sure.
lien at this stage. Yes, I think we're at one on that. Yes, Mr. Wibberley makes the point, and it's with respect, and I think it's a valid one, that the notice tells us that in the event that it's a CFA light, there is no right to recover costs, and so that Haven can proceed on the basis that there is at least a strong possibility, we would say probability, that there is no right to recover costs from the client, so that no question of recovery will arise. And what we say about notice is that before the equitable intervention of the court can be justified on the basis of notice, the paying party must have been on notice of sufficient facts to establish the solicitor's entitlement to costs from the client. And that goes back to the point that I've just made, that costs from the client, there was no entitlement. And we say it simply wasn't for Haven to speculate as to what the nature of any such entitlement might be. Nor was it for Haven to speculate as to any cancellation rights of the RTA claimants in respect of their CFAs. It's true that, in fact, in this case, there were no cancellation rights extant, but whereas the Court of Appeal described that point as a red herring, certainly as far as Mr. Tonkin was concerned, Mr. Tonkin had told Haven that he had a 14-day cancellation period. He'd entered into his CFA on the 16th of April. The settlement was agreed on the 23rd and concluded on the 24th. So it didn't matter what the position actually was. As far as Haven's notice was concerned, there were cancellation rights in respect of Tonkin. And we say that not only was there no notice of any entitlement under the protocol, that on the facts, the inference to be drawn from the telephone transcripts and the way that the settlements developed is that Haven believed that in settling directly with the RTA claimants, there would be no solicitors' costs to pay, precisely because there was no entitlement. Now, it's one thing to be cheating the solicitor out of his costs if the solicitor has an entitlement, but if your belief is that the solicitor has no entitlement, it cannot possibly be said that you're interfering with his contractual rights or with his entitlement by cheating him out of it, because you settle in the belief, whatever one thinks of the moral probity or otherwise of the settlement, you settle in the belief that there is no right to costs. My lady, may I just refer you briefly to page 1331. This is Mr. Granell's conversation with Mr. Ralph McLaren, and Edmondson make a great deal of it. And the answer they rely on is the one that starts, as I say, they'll probably, when you speak to them, they'll probably tell you not to, or you shouldn't do that. But for them to be honest with you, if when they call you, probably a bit less, the reason we offer a bit more is because of the fact that solicitors get kept out of it, so we don't have to pay their fees. That's basically it. The point there is that there is no entitlement. Haven believe they are perfectly entitled not to pay the fees. They're not trying to cheat anyone. There is no obligation to pay, and if there's no obligation to pay, they can pay the RTA claimant a bit more. And with Tonkin the same, 1309, Louise Richardson, 2/3 down the page. But at the end of the day, that offer will come from myself. That is the Haven offer. And we, through solicitors, we have to pay the solicitor costs as well. So the view of both Haven representatives expressed there, and we say correctly, is that far from Haven having any notice of entitlement, Haven is acting in the belief that there is no entitlement. And if there's no entitlement, then we say there can be no question of there being any payment, to use the words of the authorities, in fraud of the notice, which comes from Welsh and Hull, or violation of the notice, which is Lord Kenyon in Reed and Dupper, or in disregard of the notice in Ross and Buxton.
Well, a mere belief that the notice isn't notice of any kind of entitlement wouldn't of itself mean you didn't have notice. I mean, your case really stands and falls on the nature of the notice, doesn't it? On the nature of the underlying entitlement, which you say there wasn't. I mean, I know the word in fraud is used in those contexts, but it doesn't normally mean red in tooth and claw fraud. Equitable
I'm
fraud.
perfectly happy to take it at its minimum, disregard of the notice. The point being that the bona fide compromise is valid in the absence of notice that the solicitor has an entitlement. There cannot be either disregard or violation or fraud of the notice if the party forming the bona fide compromise acts in the genuine belief that there is no such entitlement. So I would go a little further than my Lord Briggs, who is saying, well, or suggesting that if there is no entitlement, we're right, but if there is an entitlement, it doesn't matter if you didn't know about it. We say that if we don't know there is an entitlement, we haven't got notice if it's sufficient to give us notice of an entitlement, then there is no effective notice, and you can't get the notice route to governance liability.
There are two possible scenarios there. One, that you have notice of the facts which give rise to entitlement, and 2, while you have notice of those facts, you believe wrongly that that doesn't give rise to entitlement. Now, if you wrongly believe that there is no entitlement, the notice is still sufficient, isn't it?
Well, that's the heart of the difference between Lord Briggs's formulation, as he's just put it to me, and my submission.
Well, I didn't put it quite like that because I hope it was understood to be bolted on to my earlier suggestion that a possible answer was that if you know it's a CFA, then there is some, even if it's a CFA light, irreducible minimal level of entitlement, which may or may not be sufficient.
Yes, and that's subject to the argument that a contingent entitlement that hasn't yet arisen is not an entitlement of which notice now would make any difference.
Yeah.
But I accept Lord Carr's point that it can be put in that way, but I invite you to reject that way of looking at notice. There are 2 alternative routes to equitable intervention. One is collusion, and the other is notice. Notice is notice of the entitlement. And if the person given notice honestly believes that the facts of which he has given notice do not give rise to an entitlement, then I say that is insufficient notice. It's not actually arisen on any of the cases, because in all the cases, the solicitor has been saying, I have a right to costs, it's an established right, I give you notice. As a result of that notice, you must not pay my client, you must pay me, or other relief. Now that is notice where the entitlement is directly established. In this case, if I am right, even if there is either a vestigial or a substantial entitlement in the solicitors, if Haven pay only upon the basis that the facts of which they have notice do not give rise to an entitlement, in other words, we do not have to pay the solicitors, that in my submission cannot amount to a notice of an entitlement effective to justify equitable intervention. That's our submission. My lady, if I may come to our next submission, that there was no collusion between Haven and the RTA claimants. This is issue 5 in the Statement of Facts and Issues. The judge set out the agreed position at first instance. At paragraph 22 of his judgment, that was MS 1237. For a finding of collusion, it is agreed that both parties to it must have the aim of keeping the settlement sum away from the solicitors to cheat them out of their fees. There was a finding of fact at paragraph 23 of his judgment that there was no sufficient act of collusion between any of the clients and the insurer. And he said, while the insurer in each case did intend to avoid paying the solicitor's costs, the RTA claimant's aim was simply to secure quick settlement of their claims. Edmondson is quite specific in its written case at paragraph 96, which is MS 1179, that it does not seek to overturn the trial judge's finding of fact. Furthermore, it concedes, and this is paragraph 4.5 of its written case, at MS 1136, that there was no, and I quote, collusion in the orthodox sense. However, Edmondson advances a case at paragraph 96 of its written case, which is based on the proposition that collusion may be established where parties do not have what my learned friends call the same level of intention to deprive the solicitor of his fees. And they rely on 2 cases, Margetson and Jones, which is tab 21 in the second volume of Authorities at MS 265, and the case of Singinia against Burrell and Pine, which is tab 46 of the third volume of Authorities at 548. Before I turn to those authorities, we submit that the appropriate way to approach the question of intention is effectively that adopted by Lord Hoffman in relation both to inducing a breach of contract and or causing loss by unlawful means in the case of OBG Limited against Allen, and there are copies in court, which I hope you now have. I'm afraid a very large amount of paper has been expended in producing 2 short paragraphs. But the paragraphs on which I rely are first on inducing a breach of contract at paragraph 43 on page 940. And this is 2007 2 weekly law reports. And this is on the question of whether the breach of contract is intended. On the other hand, if a breach of contract is neither an end in itself nor a means to an end.
Sorry, which paragraph are you?
Paragraph 43, my lady.
Thank you.
940. If the breach of contract is neither an end in itself nor a means to an end, but merely a foreseeable consequence, then in my opinion, it cannot for this purpose be said to have been intended. That, I think, is what judges and writers mean when they say that the claimant must have targeted or aimed at. And we're here concerned as to whether any collusion between Haven and the RTA claimants was intended to prevent the solicitors getting any fees. And it's a response to Edmondson's argument that because the agreement that was made between Haven and the RTA claimants was foreseeably going to have that effect, in other words, they knew the solicitors wouldn't get any fees, that was its intention. And we say that is not what is meant by intention. And in relation to causing loss by unlawful means, if I could invite you to turn forward to paragraph 62 at page 945. Finally, there is the question of intention. In the Lumley against Guy tort, there must be an intention to procure a breach of contract. In the unlawful means tort, there must be an intention to cause loss. The ends which must have been intended are different. South Wales Miners' Federation against Glamorgan Coal shows that one may intend to procure a breach of contract without intending to cause loss. Likewise, one may intend to cause loss without intending to procure a breach of contract. But the concept of intention is in both cases the same. In both cases, it is necessary to distinguish between ends, means, and consequences. One intends to cause loss, even though it is the means by which one achieves the end of enriching oneself. On the other hand, one is not liable for loss which is neither a desired end nor a means of attaining it, but merely a foreseeable consequence of one's actions. We submit, in summary, that this approach leads to the correct conclusion that a compromise does not cease to be bona fide by reason of collusion, even if its foreseeable effect is that the solicitor will not have a lien in respect of any costs he is owed by the client, provided that the purpose of his entering into the agreement is not to cheat the solicitor out of his fees.
Lord Marks, can you just remind me, I was, of course, party to OBG, and I know there were complex interrelationships between who agreed with whom about what.
Yes.
Was there a majority agreeing with Lord Hoffman on these points?
My recollection is that this was unanimous, but I'll check that, or I'll ask.
Well, it's more agreeing with every aspect of the reasoning.
It's the reasoning on this point.
On this particular
there were other
point.
areas.
Yeah, there were other areas. Yeah, well, the main disagreement was as to the potential for expanding the tort of conversion into.
Yes, lady, that's absolutely right. But
I also have a recollection that other members of the appellate committee also delivered judgments, and they may not have said exactly the same thing about all of this.
So they did.
Lord Nichols, for example.
Lady, can I have a look?
So if you're going to rely on Lord Hoffman, it would be nice to know where his...
Yes, I hope I may either put in a short note or have a look at that overnight.
It would just be helpful. I mean, it may be common ground, but I'm not
Certainly this
anticipating
formulation
anything
of
to be
intention
common
was
ground.
never challenged at the trial, where we were, of course, considering unlawful loss, causing loss by unlawful means and inducing a breach of contract. But unanimity on the definition of intention, I'd like to look at. But I do say that the Hoffman formulation is consistent with the words used by Mr. Justice Denman in Price and Crouch, which is tab 31 in volume 2 of the authorities at MS 362, and Mr. Justice Whiteman in Brunsden and Allard, relied upon by Mr. Justice Denman, when he said that the question was the object of the arrangement to deprive the plaintiff's attorney of his costs? And we say that here there is no question of that being the object of the arrangement. The object of the arrangement was to achieve a speedy settlement of the claimant's claims.
And in a way, that meant there was no liability for costs.
Yes. Which comes back to my earlier point. No liability. We don't have to pay the costs. You'll get a bit more, and you get it now. And when you look at the transcripts, you'll get it now was a very powerful motivation. And we say when one comes to policy, the interest of quick settlements in these cases is a very important one. Lady, I just mentioned that the other passages in Brunsden and Allard at page 41 to 44, and those passages I read in Sullivan and Pearson are also relevant on this. If I could come briefly to the Hope, the 1883 case, that was the case, the readership will remember, where two seamen sued the owners of the Hope for wages. The parties compromised the claim privately. The seamen left the country without paying their solicitors, who complained this was an agreement reached behind their backs. And Lord Brett made it clear, this is at MS 162, the Hope was at tab 13 in volume 1 of the authorities. Lord Brett said the plaintiff's solicitors must show that both the plaintiffs and the defendants entered into the compromise with the intention of depriving them of their lien. And Lord Justice Lindley said, there is no rule that the parties may not compromise an action without the intervention of their solicitors. They must, however, do so honestly and not intend to cheat the solicitors of their proper charges. My lady, in our written case, we cited Lord Justice Lindley's approval in that case of the rule laid down in Chitty's Archbold practice, which is set out at MS 163 and was relied upon by the Court of Appeal in Cairns. And we say as an important statement of the general principles underlying the jurisdiction concerning lien compromise and collusion. And my lady, it's significant that in Manley and the Law Society, paragraph 21, page 1236, Lord Denning relied on the observation of Lord Brett in the Hope about both parties, both plaintiffs and defendants must have entered into the compromise with the intention of depriving the solicitors of their lien. And we say that those cases are clear authority against the proposition that is advanced by Edmondson that in either that a different level of fraudulent intent is required of each party. Coming to those cases in Margetson and Jones, it's perfectly true that Mr. Justice Kekowicz, this case is as reported is in tab 21 of the second volume of authorities. The passage starts at MS 270, and he found that there had been a distinct case of a cheat. He found that the paying party, Mr. Jones, had acted with the intention of cheating the solicitor, Mr. Margetson, of his costs. And although he said he didn't think the clients, Mr. and Mrs. Pugh, realized their impropriety and were persuaded by Mr. Jones to do what they did, and it's that fact that leads Mr. Crowe to say, well, a different level of culpability will do, he still said he could not quite acquit them of the cheat. So that he was saying they've both got to be parties to the cheat, even though he said Jones was the wickeder of the Jones and the Pews. And what is very important is that in setting out the principle, the judge cited the first passage I read from the judgment of Lord Justice Lindley, and he added, the word cheat is not a bit too strong. The Master of the Rolls, referring to Lord Brett, also uses it. In Siginia, a 1934 case in the Calcutta High Court, that's at tab 46 of the third volume of Authorities, at page 548, Mr. Justice Costello went through the authorities we've cited and others, and he came to the conclusion that the first instance judge was entitled to come to the conclusion the parties intended so to arrange matters as to defeat the solicitor's lien. And it's certainly true that at one stage of his judgment, and this is at paragraph 24 on page 556, he said this, putting the matter in another way, it should generally be held that there is collusion if the agreement between the parties is made with the knowledge that the result will be to deprive the solicitor of his costs which he has earned. There is certainly collusion if the parties enter into an agreement knowing and intending that the outcome will be the solicitor is deprived of his lien. Now, no doubt Mr. Crowe will seek to persuade you that what in the first part of that paragraph Mr. Justice Costello was saying was that foreseeability will do. We say he hit the truth in the second part of the paragraph, but if and insofar as the first sentence of that paragraph is inconsistent with the need to establish intention in the sense described by Lord Hoffman in the OBG and Allen case, we invite you to prefer Lord Hoffman's formulation. My lady, on the facts of this case, there was no evidence that the parties to the compromise believed that Edmondson would have any costs. The RTA claimants plainly knew they were not bound to pay anything to Edmondson because of the client care letter, nor can it be credibly argued that they knew or believed that Edmondson had any right to recover costs from Haven, and we say not just because Edmondson didn't, but it's quite clear that they knew, they believed there was no such right, which was Haven's reason for settling the claims quickly. And I come back to my point about Haven's state of mind, which is that they certainly didn't believe that they had an obligation to pay the solicitor's fees, and indeed that was part of their motivation. So we say no question of cheating the solicitors out of their costs on that part either. So we say that however much Edmondson may not like it, and indeed the Law Society plainly don't like it either, it cannot be cheating Edmondson for Haven to compromise the claims of the RTA claimants in order to avoid incurring a liability to costs in the belief that no such liability had accrued. Lady, that deals with what I want to say about collusion. And then I come to a submission that follows issue 6 in the statement of facts and issues, which is that the court cannot grant equitable interference if neither of the routes in Cairns, notice or collusion, is established. We say that follows from all the cases from Welsh and Hill through to Cairns. We say the analysis in Cairns was both exhaustive and right. And we do say that the jurisdiction has been relatively static over the intervening 200 years, as Sir Stephen Sedley pointed out in that analysis. And that adds to the proposition that where we're not dealing with a developing, but with a static and well-established jurisdiction, there ought not to be any decision by the Supreme Court to change that jurisdiction or enlarge it, unless the reasons for so doing were overwhelming. And we say there's no such reason in this case. But Edmondson, in its written case, and this is paragraph 99 at MS 1180, contends that the answer to this issue is yes, and that there can be other routes to equitable interference. And they rely on all the arguments in 12 to 20 of their written case. And they summarize them at 3.2. which is at 1135, and effectively what they say is that rather than being limited by requirements for collusion or notice, equity should intervene where in all the circumstances of any particular case, it is just to do so. We don't accept that equity should be enlarged in this way without authority or principle, nor do we accept that there is any reason now to extend the jurisdiction in the way that Edmondson invites you to do. And we also come back to the point that Edmondson is falling into the misunderstanding of the nature of equitable lien because they overstate the availability of equitable lien by reference to concepts of fairness and justice without appreciating the jurisprudential basis in a lien and the lien being an ancillary security right or its necessary limits. And we say that approach would lead to the jurisdiction becoming unpredictable and arbitrary. And it's significant that if you look at all the examples of statements that they cite in their written case, for instance, the reference, one example only, to convenience, good sense, and justice as justifying equity's intervention. That comes from Ormerod and Tate at MS 345. And when you analyse that decision, a very cursory analysis, shows that Lord Kenyon, the Chief Justice, who said that the principle accords with convenience, justice, and good sense, was not sanctioning any departure or any broadening of the principle at all. And that's true of all the authorities. Nor do we accept Edmondson's interpretation of Lord Mansfield's judgment in Welsh and Hull as clearly recognising the court's equitable jurisdiction to intervene without any need for the solicitor to prove notice or collusion. And if I can invite you simply to look at that very briefly, it's in MS 534 to 535, at tab 43 of the third bundle of authorities. The sentence, if he apply to the court, this is right at the top of page 535, they will prevent its being paid over till his demand is satisfied. That envisages an application to the court to prevent the paying party from making payment to the solicitor's client. And that's necessarily an application of which the solicitor would be giving notice to the paying party, whether before or after the application is heard, so that notice is bound to be given in that case. And that, we say, is the only logical explanation for the next sentence, which is, I am inclined to go still further and to hold that if the attorney gives notice to the defendant not to pay till his bill should be discharged, a payment by the defendant after such notice would be in his own wrong and like paying a debt which has been assigned. But I think we cannot go beyond those limits. So he's saying you can either go to court, in which case going to court operates as notice, or you can give notice and that will do. But it doesn't go any further than that. My lady, so we say that there is no case where Edmondson can point to relief being granted under this jurisdiction in the absence of notice or collusion, and that is for reasons of principle, not simply policy or coincidence. If I may come now, with the time remaining to me, to two submissions. The first is to consider some policy considerations. We say that certainly the Law Society and Edmondson's submissions have advanced arguments as to why the solicitor's need for protection is a public policy interest which should be given weight. We say that their arguments wrongly prioritise the interests of solicitors over other interests, notably the freedom of contract of claimants and insurers, the interests of claimants in achieving a quick and reasonable settlement of their claims, the interest of insurers in settling claims quickly and at reasonable cost, and where possible without incurring liability to solicitors for claimants, the public interest in securing early settlement of disputes, the public interest, and in particular the interest of motorists, in keeping down the cost of insurance premiums, and the public interest in certainty and predictability in the law. My lady, coming first to the interests of the solicitors on which Edmondson rely, it's clear that solicitors' interests do lie in securing instructions from RTA claimants as quickly as possible, entering into CFAs and serving CNFs also as quickly as possible. In Tonkin, the CFA was 6 days after the accident and the CNF was the next day. In Wheater, it was 3 days after the accident. I think 4 weeks after the accident, I'm sorry. Grinnell, 3 days, and the CNFs followed within 3 days. In Grinnell, the CFA was 1 day after the accident, and the CNF the same day. In this case, referral fees, or these cases, were paid in 4 cases. Wheater & Co. paid £750 plus VAT to a claim handler called Shake Promotions. And Mr. Edmondson said in evidence that 90% of his work at that stage came through referral fees. My lady, this compares with stage 1 costs, remember, at £400 a client, and stage 2 at £800 a client at that stage, and a success fee of £150, being a total of £1,350 at that stage. Very large proportion taken up with the referral fees. Now, referral fees are now banned, but there's still a strong incentive for solicitors to secure referrals quickly from claimants' insurers and run cases through the portal. The ICF report exhibited by Mr. Marshall, and the section dealing with this is at MS 837 to 844, and particularly 840 to 842, found significant evidence of the ban on referral fees being circumvented, with respondents to a survey saying that it was ineffective and that referral arrangements were still being used under a different guise or mechanism. Now, that said, we appreciate that solicitors need to market their services, but their interest in so doing should not enable them to tie clients up in a hurry and tie clients to them, and possibly at the expense of those clients' interests. And the CFA Lite, of course, enables solicitors to attract clients, as the Law Society and Mr. Marshall accept, with the prospect that under no circumstances will they have to pay any solicitor's fees. And we say it's significant that the CFA Lite has become so common against a background that, as Mr. Marshall points out in paragraphs 14 to 16 of his witness statement, and as is clear from the documents in this case, the Law Society's model CFA is not a CFA. The model CFA and the Law Society guidance contain significant protection for solicitors and a right of recovery of costs against their clients. And we see that in the section of the CFA document headed Paying Us, to which I drew your attention earlier on MS 1280. and in the section on payment in the Law Society document at 1282 to 1286. But, my lady, if solicitors choose to forego these protections by converting their CFAs into CFA light contracts, because of what are essentially marketing advantages that CFA lights bring, then they should take into account, we say, the risk that some clients may choose to settle their claims before the solicitors can recover the costs of conducting them. And we also say that it is always open to solicitors to contract with clients on different terms. They could, for instance, Edmondson could, for instance, have contracted with the RTA claimants on terms that, first, they would not settle with Haven direct, while Edmondson were instructed. Secondly, they would not enter any settlement that did not include provision for Edmondson's costs. Thirdly, that they would pay Edmondson's basic costs if they settled direct with Haven. And or fourthly, that they, the clients, the RTA claimants, would instruct Haven to pay any settlement monies to Edmondson for the reduction of their costs. Milady, the ingenuity of drafters might come up with any number of other alternative forms of protection. Our point, though, is that the CFA light adopted in this case by Edmondson exposed them as a deliberate commercial decision to the possibility of early settlement between clients and insurers. And they're not entitled in those circumstances to say that they get their costs. And I would add all the costs of taking the case all the way through the protocol, where all that happened in the protocol was they served their CNF. And I know my Lord Briggs has expressed in the past a view that work is required for the CNF to be completed, and of course I accept that. But it is not the same as taking the case all the way through to stage 2. And all they do is enter the CNF and the CNF responsible, the CNF acknowledgement, which is, as we say, a nothing, with no CNF response, no admission of liability, and effectively nothing achieved through the instrumentality of the solicitors. The freedom of contract point we make is that the right of parties to settle disputes directly between each other is not just a right as a matter of law, as we've seen, it's a matter of individual freedom, and the pre-action protocol should not be used as a tool for preventing private settlements. That should certainly be the position, and has always been the position, where proceedings are underway, and so it should be where proceedings have not yet even been started. And we say that the protocol would have to be very clear indeed if it were intended to impose an obligation to pay costs on a defendant who reached an independent settlement directly with a claimant, which didn't expressly incorporate an obligation to pay those costs. In other words, you simply cannot restrict freedom of contract by reference, for instance, to 737, to say, well, you entered into this acceptable compromise. Court of Appeal found it was perfectly open to enter into a compromise, but that compromise must carry the obligation to costs. There is an entitlement, and we will enforce it. When nobody, no party to the settlement believed that that was the case. And we go further, and we say, should it be held that equitable interference would be available to a solicitor, even though there were no accrued right for his client, or that there would be any entitlement as a result of the protocol by acknowledging a CNF, and then not taking the deliberate step of discontinuing compliance with the protocol. In other words, if you impose the case that Edmondson seek to advance, that might well have the effect of discouraging settlements, which would otherwise be of benefit to the parties. And we say there is a public interest in maintaining freedom of contract for the parties, without that kind of artificial restriction. I turn next to the interests of claimants in securing quick and reasonable settlements, and submit that all the evidence in this case, from Mr. Edmondson himself, from the telephone transcripts, demonstrates that the individual claimants were delighted, no less, to be able to settle their personal injury claims directly and quickly with the insurers. Mr. Grenell, for instance, said he'd had a little girl and the money meant a lot to him. Mr. Mosin accepted the offer because he wanted the case settled quickly, and he acted on behalf of the three other claimants in his clutch of claimants, Mr. Wheater, Mr. Makey and Ms. Lunt. And that was all to the knowledge of the solicitor. He said that the clients wanted a quick settlement, and that was their motivation in settling direct with Haven. And he said this: "You just call them up, settle the clients, we never hear anything about it. The client wants a quick settlement. He knows that a quick way is to come to you. He'll get it into his account in a few days, and that's why he's gone with you." And from the solicitor's point of view, one can understand his being a little miffed at that outcome because he doesn't get his fees. But from the client's point of view, the client has a point. He's entitled to money. He's got a claim. It's only a small claim as a result of a fairly minor whiplash injury. And having it at a time when he needs the money in his account, rather than having to go through the long and involved process, should be an option available to him. And it ceases to be an option available to him if the insurer is bound to pay the costs, come what may. And that is really the position that Edmondson seeks to achieve. The other point I'd make en passant is that contact between the solicitor and the insurer, between the clients, the RTA claimants and the insurer, is happening alongside the protocol process. The protocol process is only dealing, in all these cases, with the personal injury aspect of the case. But for driver claimants, not so for passenger claimants possibly, for driver claimants, they are also negotiating the repair of their vehicle or the write-off of their vehicle, and they are negotiating the replacement car, a hire car to replace their transport during the period of the claim. And there is absolutely no reason in justice why it should be made more complicated for the claimant who's dealing with the insurer, getting his car repaired, getting a hire car, and in Mr. Tonkin's case, having physiotherapy arranged for him as well. By then being told, well, you've got to go through the solicitors because we're going to have to pay their costs anyway, and that's the way it's done. And I would add there's no suggestion at any stage being made that any of these claimants were shortchanged in their damages. Indeed, when Mr. Edmondson made contact with Haven on the 26th of September, that's at MS 1302, to complain about what Haven had done in approaching Grenell behind his back, as he saw it, he offered to accept the £1,900 that Mr. Grenell had long since agreed to accept. Remember, there was a rather unfortunate interlude in Grenell because an imposter took his money, and Haven ended up paying twice in any event. But the fact was that Mr. Grenell only hadn't received his money very shortly after the accident because the cheque had been stolen by that imposter.
Lord Marks, I'm going to behave like a chairman at a conference, and I was going to hand you your 5-minute warning. I'm now going to hand you your 4-minute warning.
I will do my best to keep to that.
No, you stop. You stop at the end. When your time runs out, it's up to you how you use it. You stop.
Insurer's interest, I have spoken of. The public interest in encouraging early settlement, I've spoken of in outline.
He's got 4 hours, yeah.
You've got 4 hours. What was
Sorry?
2.5 and 1.5? 11. Oh, it's 11. I forgot we started at 11.
Yes, I'm
Forgive me, you have got until 4
supposed to
o'clock.
have another 33
You
minutes.
have indeed. I had forgotten we started at 11. I've been so fascinated.
Yes, I'm sorry, I thought you were being a slightly unfair chairman of the conference.
Well, you should have come back to me.
But I'm very used to,
Delighted
very
my
used to
Lord has put
that.
me
I'm
right,
afraid.
'cause I had forgotten it was Monday.
Okay. Well, in
4
that
minutes
case, if I'm-
encouragement. If not a
Slow
4
down
minute warning.
slightly.
You can slow down now.
You didn't look quite as upset at my submissions as might have been suggested. At any rate, I will, I think, finish before 4 o'clock. But what I do say is that the insurer's interest is plainly in settling cases at reasonable cost. A direct settlement offers speed and, we say, no payment of costs. The public interest in encouraging early settlement, we say, is very important. There's also certainly a public interest in enabling access to justice for those who cannot afford privately paid legal representation, a point that Mr. Crowe makes. However, CFAs were designed to and can achieve that, which is why they were made lawful. But this particular type of CFA light is not necessary to achieve that aim. It may be attractive to solicitors as a marketing tool, but generally speaking, an ordinary CFA will get the client there in any event. And I make the point again that it's open to solicitors as to how they contract with their clients to secure protection. Lady Edmondson argues that equity should intervene to protect the legitimate interests of solicitors, and we accept that entirely, but the point I make about contract is that it's for solicitors to protect their own legitimate interests by contracting sensibly with their clients, and if they take a commercial decision to enter into risky contracts, in order to make the contracts more attractive to their clients, then they must take responsibility for that commercial decision. Lady, may I mention the proposed reforms very briefly? These are described by Mr. Marshall at paragraph 26 of his witness statement, which is MS 793. Broadly, all RTA personal injury claims up to £5,000 will be within the small claims track. And as we discussed earlier, that means that all those claims, and therefore all these claims, would have been small claims track, no solicitor's costs recoverable, and no such claims would be within the protocol. And it follows that all these claims, and all whiplash claims generally, will not attract orders for costs fixed or otherwise. Now, Mr. Marshall says that the Law Society estimates this will mean that 96% of all RTA personal injury claims will move to the small claims track and outside the protocol. And the government clearly takes the view that these claims can be satisfactorily handled without the involvement of solicitors. We say this is significant in this case because direct dealings between insurers and RTA claimants are likely to become the norm and likely to do so as a matter of government policy. Of course, it remains to be seen how the handling of these claims will develop. Arguably, there'll be increased scope for the involvement of claims managers, handling claims on behalf of claimants, possibly offering their services in return for a share of damages. There's bound to be an increase in claimants handling their own claims. The point about offering services in return for a share of damages is important because as a result of the Jackson reforms where success fees are no longer recoverable, solicitors are entitled to, and frequently do, and there's been litigation about it, seek to deduct from the damages payable to clients a proportion of the success fee that they're charging their clients but cannot recover from the insurer. That adds to the public policy, we would say, of enabling clients and insurers to deal directly, because although the insurers now don't have to pay the client's success fee, the solicitor's success fee, the poor client claimant is stuck with some of it in many of these cases. And if direct settlements are in any way outlawed, that, of course, leaves clients more vulnerable to success fee deduction contracts. Then we also say that the public interest lies in reducing insurance premiums, and that's plainly something from all the publicity that's been given and what's been said about it, that has motivated the reforms that are proposed. Mr. Marshall makes the point that the incidence of fixed costs regimes in civil litigation is likely to increase, and he points out that there's going to be a new fixed cost regime for all fast-track cases and an intermediate track for higher value cases, and that the portal processes have been extended to cover much higher value RTA claims and also employers' liability and public liability claims to 25,000. Now, he may well be right, but what the effect of that will be that the areas of litigation covered by fixed costs regimes will plainly be broader. But it doesn't mean that the effect of moving these vast number of very small RTA claims to the small claims track will reduce the number of claims covered, because the number of claims covered will be largely these claims. Now, it is not for us to speculate, or indeed for this court to speculate, as to how solicitors will respond to dealing with a broader range of cases and more complicated cases on a fixed costs regime. But I do come back to the point that it's unclear that these cases will be dealt with by CFA-light type contracts. It's unclear how solicitors will decide to contract with their clients. And I reassert the point that it is for them to decide how they wish to structure their contractual arrangements so as to ensure that they receive fixed cost recovery. And I don't accept the point made by my learned friends that the only way to ensure fixed cost recovery is to allow the extension or the entirely new jurisdiction, as we would say, for equitable intervention. My lady, finally on public policy, I say that certainty and predictability in the law is of great importance. It's always been of great importance. If the law is fudged as to when equitable interference will be granted or equitable intervention, that makes it difficult for everyone, claimants, advisors, insurers, to predict when there will be such interference. And we say that the siren call of the claimants in this case to simply rely on considerations of convenience, fairness, and justice runs the risk of fudging. My final submission is that the court shouldn't intervene in the circumstances of this case, even if it has jurisdiction to do so. We've dealt with, in our written case, the proposition that had the solicitors been able to sue in their clients' names, then they should have done so, and equity will not assist a party who slumbers on his own rights. We make the point that the Court of Appeal held at paragraph 37 of its judgment, 1229, that Haven could have made an offer conditional on cancellation of Edmondson's retainer. In fact, we haven't looked at paragraph 37, 1229. More fundamentally, I consider the fact that an offer may have been made at a time when a retainer was still cancelable or otherwise terminable cannot relieve Haven of liability. In each case, Haven, with knowledge of the existence of a CFA and that the claim was proceeding within the protocol scheme, made an offer of settlement with no express limitation as to the period within which it could be accepted. It would have been open to Haven to make the offer conditional on cancellation of Edmondson's retainer within the permitted period, but it did not do so. In each case, Haven assumed that its offer might be accepted after the expiry of the cancellation period. In the event, none of the underlying cases was the retainer cancelled or otherwise terminated. Lady, what we say about that is that it is entirely artificial to permit equitable intervention in a case where the only reasons why it's available are that, in this case, Edmondson failed to make cancellation of the retainer a condition of the offer, or that Edmondson failed to wait for the 15 days upon the expiry of which the claim would not have continued within the portal in any event. Those are points that are entirely valid, and it's accepted that they're entirely valid. But to make the availability of equitable intervention dependent on those factual points is, we say, an inappropriate use of the court's jurisdiction.
Lord Marks, had these claimants not waived their entitlement to cancel?
What they've done is they've said, please start work, and we will pay for the work. They haven't, I think, waived their right to cancel.
I was looking at 1281.
Waived.
If you've got that to hand,
Yes.
which is the second page of the CFA in Mr. Granell's case.
Yes.
Fourth line down from the top, it's been explained to me I have a 7-day cooling off period.
Yes.
I want Gavin Edmondson to undertake work on this file with immediate effect.
Yes.
And I waive my right to the cooling off.
Yes. There is some doubt as to the effect of that, as to whether the right to cancellation is altogether lost, or whether the cancellation would only take effect subject to the requirement that the solicitors work and get paid for their work.
Is there an anti-contracting out?
Dealt with it, I think, paragraphs 19 to 21.
I see.
Is there an anti-contracting out provision in the
Yes.
regulations? In what terms?
Yes, Mr. Wibberley will find it, but there is. That's when I mentioned the statutes that interfered with freedom of contract, that was the example that I gave, that you can't contract altogether out of the cooling out period.
Yes, very well.
Sorry. The Court of Appeal's assumption was that the waiver was ineffective.
Yes, I see that. Yes. Paragraph 21.
Paragraph 19 and 20. 19
Thank you.
21. And in that connection, it's section 15, as the paragraph 15, rather, the cancellation of contracts made in a consumer's home or place of work, etc., regulations 2008, which is the anti-contracting out provision.
Thank you.
Edmondson's never argued and couldn't argue that had the retainer been cancelled, it would have had a continuing right to recover costs from the RTA claimants. And it's never argued that if claims had left the protocol process after the 15 days or on any other basis, that it would have had any right to fix costs. We say, of course, that once they dealt directly, the RTA claimants and Haven, we were out with the protocol in any event, and I've developed that submission. But if it is right that the claim could have fallen out of the process simply on the expiry of 15 days, how can it be right that equity should intervene to establish a right to intervention because the 15 days hadn't elapsed? Or because the clients hadn't cancelled their retainer? We say those are trivial considerations that could not possibly justify a change of approach to equitable intervention. Two final points. The first is that at no stage did Edmondson ever inform the RTA claimants that they might have a right to deal direct with Haven in respect of their personal injury claims. They knew the driver claimants, at any rate, were likely to speak to Haven about their other claims. And we would say that arguably a solicitor acting in the best interest of his clients would have a duty to speak to the clients about the possibility of settling personal injury claims direct in order to do it speedily outside the protocol. That never happened in this case, and as far as we know, hasn't happened in other similar cases. And the final point is taken by taking the example of Mr. Tonkin. Edmondson did nothing to generate the settlement offer in Mr. Tonkin's case. Haven, as you will have read, had the details from its own insured, the negligent driver, or allegedly negligent driver, there being no admission of liability. Haven secured details of Mr. Tonkin's injury from Mr. Tonkin and made him an offer to settle. And after that, it was Mr. Tonkin who contacted Haven in the course of talking about a replacement car and repairs and so forth. And neither Edmondson's role as solicitor nor the submission of the CNF played any part in bringing about Mr. Tonkin's settlement, because they had all the information already. Now, that must happen in very many cases. I just say this, in any case where the facts are that the insurer for the allegedly negligent driver is getting all the information it needs from the RTA claimant, why should the insurer not make an offer to settle the personal injury claim? It doesn't in any sense restrict the claimant's right to see solicitors or right to take advice from whomsoever. After the new regime kicks in, with the new regime in on the small claims track, that's going to happen in any event. And we say it's an unwarranted interference with the freedom of the RTA claimants to introduce equitable intervention in those circumstances. Lady, those are my submissions. I'm a little before 4 o'clock.
Congratulations, Lord Marks. Thank you. Mr. Carpenter, do you wish to follow? No. Mr. Crowe.
In 1859, Mr. Justice Earl in Brunston and Allard moved along. In Brunston and Allard in 1859, Mr. Justice Earl said the words equitable lien are intensely undefined. I would imagine after your Lordship and your Lordships have given judgment that may not be said in a few weeks or months' time, but the starting point is that this is not an area of the law that has received a great deal of scrutiny, never scrutiny at this level. And it is a jurisdiction that has existed without question for over 200 years, but it has not been subjected to particularly detailed scrutiny. And one of the problems that you do face when you're looking at the case law is that the language that is used is sometimes imprecise. I'll point out a few examples of that, which just adds to the pleasure you will take in untangling the lack of clarity that we've been suffering with until now. I was going to use our written case as a road map, and I think one can pick it up if I could invite you straight to page 1137. Where we just lay down what I think are now probably relatively clear ground rules, which is that the common law lien, properly so called, is the possessory lien or the retaining lien, and that is passive in the sense that it entitles the solicitor to hang on to documents or funds, but it does not entitle him to enforcement action. The equitable lien, as it's described, is the thing that we will have to look at in a little more detail. The statutory charge is the third form of a remedy that a solicitor might have. And we do maintain the objection we made to my learned friend's description of that as a codification. of the common law or equitable position, because self-evidently the statutory charge was introduced specifically in order to do something that the general law was not doing. So we are moving on, page 1138, paragraph 7. Obviously, we are dealing in this appeal only with the solicitor's equitable lien. And in order to try and clarify exactly where the law currently appears to be, we have approached the issue by reference to 4 headings, the first of which is simply the nature of the jurisdiction. As we point out in paragraph 8, it has been fairly said in this context that the term lien is really a misnomer. In truth, a solicitor's equitable lien is merely a right to claim the equitable interference of the court. That is common ground. It is important. It is a point that is made over and over again in the authorities. Can I just give you the case names for the sake of completeness, not because repetition makes the point any better, but simply in order to underline the point that it is absolutely ingrained that what is described as an equitable lien is simply an equitable interference jurisdiction. Those words, the right, merely a right to claim the equitable interference of the court, they have appeared in Barker and St. Quintin, which is in Authorities Bundle 1 at tab 2, or if you want the electronic page, that is 28. It's used in Re Games, which is Authorities Volume 1, tab 9, which is electronic page 72. And I was going to go 2 games, but I might just finish the list before I do. It's, again, exactly the same expression is used in James Bibby, to which you were referred, which is Authorities Volume 1, tab 14, and the relevant passages are in the report at page 453 and 455, which is electronic pages 168 and 170. It's used in Re-Fooled, the decision of, I think, Mr. Justice Scarman, as he was in that case, which is Authorities Bundle 1, tab 8, electronic page 58. In Glasgow and ELS Law, Authorities Bundle 1, tab 10, electronic page 75. In Mason and Mason, to which I think you've already been referred, which is Authorities Volume 2, tab 22, page 273. And in the Indian case that Milan, your friend, has also referred you to, which is Authorities Bundle 3, tab 46, paragraph 13, which is electronic page 552. Having just run through that list, could I then go back to the case I said I would? That's Games, which is Authorities Bundle 1, tab 9, and electronic page 72.
Are you at some stage going to deal with the question what constitutes interference, equitable interference?
Yes.
And what the juridical basis of that is?
Yes.
Fine. I'm not asking you to do it any.
The facts in ex parte Games were simply these, that the plaintiff had got a costs order against a defendant, but then released him. The plaintiff's solicitor sought an order that either the plaintiff, his own client, or the defendant should pay the costs on the ground that they were colluding to deprive him of the costs. And the question then arose as to whether or not the solicitor was entitled to the order, and the order in that case, the order for the payment by the plaintiff or by the defendant was upheld. It may be convenient if we just look briefly at the decision, electronic page 73, Chief Baron Pollock, because it captures quite a lot in a relatively short paragraph. So halfway down page 544 of the English reports, page 73 in the electronic bundle, where his lordship said, "I am of the opinion that the rule ought to be discharged." So procedurally, that meant that the solicitor got his order. "I think that the court is bound to see that justice is done, and they are not prevented from exercising their equitable interference in this manner because no express authority has been cited in support of it." Now, I just pause there because in those 4 lines, you get a clear statement of the guiding principle, which is that justice should be done, and the fact that because the jurisprudential basis of the jurisdiction is in equity, the fact that no express precedent had been cited did not discourage the court from making the order that was sought.
But there's got to be some principle, hasn't there?
Of course.
Identifying what constitutes justice in this context.
Of course. Of course. And different results will follow in different cases, and different remedies may be ordered depending on the facts. Nobody is suggesting that the jurisdiction should be exercised in an unprincipled manner, but it is a general jurisdiction.
You'll remind me, I'm sure I ought to know off the top of my head, what was the source of the Court of Exchequer's power to exercise equitable jurisdiction in 1864?
I will remind you tomorrow.
Surprise.
That's what I thought you would say, Mr. Gavin. You must have thought he had it, so there we go.
We get a slightly clearer view about what sort of interference we're talking about in the last sentence, don't we, of Chief Baron Pollock's judgment, quoting from Baron Park in Baker and St Quintin.
Yes. Yes. Exactly. You probably have all now read on, but the intervening words, "No doubt in general the court cannot upon motion order one man to pay over money to another unless the former be an officer of the court and the money was received by him in that character." So just pausing there, what one gets from that is one of the many different elements that go into the equitable jurisdiction, in part, insofar as orders have been made against solicitors, it is an expression of the court's control over its own officers. But it is not only that, because orders are not only made against solicitors, they are made also against parties. And so his lordship goes on, having said no doubt in general, it wouldn't normally order against anyone other than an officer, but, he says, the court has entire control over the proceedings in a cause, and notwithstanding judgment is signed, they may, in the exercise of their equitable jurisdiction, set aside a release or make any order consistent with the practice and procedure of the court so as to suppress collusion and fraud. So there one gets an indication not only that the jurisdiction may be founded in controlling the conduct of the officers of the court, but actually as an expression of the court's inherent jurisdiction in controlling the process before it. And he says Brunsden and Allard, in Brunsden and Allard, the court would have interfered if the compromise had been collusive. He adheres to what Baron Park said in Barker and St. Quentin, and then you see the words, the lien which an attorney is said to have upon a judgment, which is perhaps an incorrect expression, is merely a claim to the equitable interference of the court to have that judgment held as a security for his debt. And then Baron Martin adds to that. I won't read it all, but if you just go on to the next page, you do see an interesting take on who is really entitled to the costs when a claim has succeeded in producing a recovery. Because a lot of what Baron Martin is actually saying that, yes, the costs order as a matter of form is made in favour of the winning party, but the attorney who has actually incurred the fee, the expense of running the case, is the one who is really entitled. And he says right at the end, just before Baron Chanel's judgment, he says, when I made the order, I thought that either the plaintiff or the defendant ought to pay the attorney, who is the real creditor. And I've heard nothing to induce me to alter that opinion. And then you'll see a final judgment of Baron Chanel, who ends up the last couple of lines of his judgment, say, referring to Baker and St. Quentin again, authority that a sheriff who actually executed a judgment that had been released would be a trespasser. But it also decides that the remedy is by application to the equitable jurisdiction of the court to compel the parties to do justice. What my brother Bramwell suggests is only a more circuitous mode of arriving at the same result. So one gets in those, just in that page really, and in our submission, quite a helpful encapsulation of the guiding principle and the kinds of considerations that the court has taken into account in this jurisdiction. I was going then to briefly deal with a question my Lord Sumption asked of my learned friend about priorities and the winding up.
Well, do you wish to deal with that now, or?
Can I just perhaps give you the page the case references, because I don't entirely agree. My learned friend referred you to meter cabs, which does deal with the point, but he said you'd get a different answer from James Bibby. You don't, because James Bibby was not dealing with an insolvency. It was dealing with competing claims in the context of garnishee order. And the question there, in James Bibby, which is Authorities Bundle 1, tab 14, the question there was where a garnishee order had already been made, whether a solicitor's lien had the effect of operating as a proprietary claim to the fund, to which the answer was no. But I think with respect that the decision that does actually help most is Reborn, which my learned friend took you to, but without taking you to the facts. Reborn is Bundle 1, tab 3, page 34. Reborn was a case arising in the context of a corporate insolvency. It shows the passage my learned friend did read to you at page 36, electronic page 36, page 435 of the report, does actually demonstrate that the solicitor's lien does take priority in a winding up. And although if you go back to it, my learned friend read you the words, it's plain that they, the solicitors, have a common law lien on the company's share of the fund in court, he doesn't actually mean a common law lien, properly so called, because the common law lien is the lien that the solicitor exercises in relation to something in his own hands. But it's perfectly clear from from the statement of facts and from the judgment itself that the fund in that case was a fund in court. So when the judge, it's one illustration of what I said, of the imprecise language. What the judge actually means when he says a common law lien is a lien under the general law, as opposed to a statutory charge, which is what was being sought in that case. And so it is quite clear from the decision that where the judge is saying that the solicitor has a common law lien on the company's share of the fund in the court for the amount of their costs, justice calls for the lien to be asserted, and it does take priority in the winding up. So I think Reborn is the most useful answer.
It is in effect a charge.
Yes.
Thank you.
Sado.
That's a very convenient moment. We will now adjourn and look forward to hearing from you further. At 10:30 it is tomorrow, and I'll do my sums.